Welcome everybody to today's slightly delayed Law of Self-Defense show. I am, of course, Attorney Andrew Branca for the Law of Self-Defense. Thank you. Thank you very much. Sorry about the delay. When I ride the motorcycle into work, I generally don't bother brushing my hair beforehand because I'm going to be wearing a helmet. So I brush my hair in the office, and sometimes I don't remember until I'm about to go live and I see my image on the computer, and I look like a madman with unbrushed hair. So I had to take care of that. Sorry, my apologies. But today we're here to talk about a very interesting use of force event, and that involves something called a CartNarc. Cart, like shopping cart, narc, or cart Karen, as I would refer to them. These are apparently people who have the free time to be angry about people who don't return their shopping carts in the appropriate place at stores. And well, I guess anybody might feel unhappy about this. They actually pursue these people and offer to put embarrassing magnets on their vehicles for having failed to return a shopping cart. And then apparently they're astounded to discover that the people they're looking to embarrass in public are not amenable to that treatment and might take offense. In this particular case, the person who took offense at being chastised for not returning their cart properly displayed a gun and cycled a slide at the CartNarc. So that's the video we have to share with all of you. This happened in Texas, so we will take a look at Texas law and ask the question, could the person in the vehicle challenged by the CartNarc, could his display of a gun, cycling of the slide, clearly in a manner intended to, well, I think in a manner intended to intimidate the CartNarc, who certainly ran away very quickly when he saw the gun, could that possibly be lawful? That kind of threat of deadly force. We'll take a look. So with that introduction out of the way, let me just take a quick look to make sure we're streaming where we need to be streaming. And of course, I'll pop up, make sure my Twitter stuff is pinned. Oh, I forgot to put out the Twitter announcement today. Sorry about that. Twitter, X. And it looks like everything is working. Except, of course, for Rumble. You never know if Rumble's working or not. I want to love you, Rumble, but you make it so difficult. Just can't tell. All right. Maybe I didn't do Rumble correctly this time. Sorry about that, if that's the case. Everywhere else, we're streaming correctly. So let's go ahead and launch the show proper, and I'll be back with all of you in just a moment. Here we go. Welcome back, folks. Welcome back. We're going to, I forgot to pull up my little video of the CartNarc. I believe I have it right. Yep, I do. Okay, so that's ready there. By the way, many of you may have seen the, there's a video clip going around on social media about a group of motorcyclists in Philadelphia who apparently got angry at a car, and one of the motorcyclists smashes in the rear window of the car. And it's in fact an excellent way to get yourself shot, even in Philadelphia. So that's not the topic of today's show, but it is the topic of tomorrow's show. So be sure to join us at Law of Self-Defense tomorrow for our legal breakdown on the legal implications of deciding to jump on the rear window of an occupied vehicle and smash it in, and then confront the owner of the car with a gun in hand. Great way to get lawfully pew-pewed for sure. But that's tomorrow's show. Today's show is about the CartNarc. And before we jump into that, I, of course, am obliged to mention our sponsor of today's show, which is none other than Law of Self-Defense itself. So this Saturday, October 7th, we're doing the last Law of Self-Defense Advanced class for 2023. This is our full day course of instruction on defense of yourself, defense of others, defense of property, interacting with the police in the aftermath of a use of force event. We spend almost an hour talking about that alone, how to devise your own legally sound self-defense strategy. We only teach this class twice a year. It'll be another 6 months before we get to it again, folks. Spring of 2024. And there are only a few seats left. So this is a live streamed class over Zoom. We have a maximum number of seats on our Zoom account, and we're reaching that limit. So if you want to understand the actual law of self-defense, this is the class to do it in. By the way, we have many people who take this course 3, 4, 5 times. It's such a fire hose of information. Especially if you've never taken it before, now would be the time to do it. Don't delay. You don't know when you'll be attacked, when you'll be compelled to defend yourself, when you'll need to know where the actual legal boundaries are for the use of force in defense of yourself, your family, your property. Time to learn it now, folks. This Saturday, October 7th, go over to that URL, lawofselfdefense.com/advanced, and learn a lot more about what this course covers and how to register. In fact, I'll put a little banner across the bottom of the screen right there to facilitate all of that. All right, so we have this guy in a parking lot, a CartNarc. He observes shoppers, and if a shopper does not return the shopping cart where it's supposed to go in those little corrals that they set up, but just leaves it on the grass or whatever the case may be, the CartNarc will confront that person, chastise them for their poor social behavior, and threaten to put an embarrassing magnet on their vehicle. That's what we're going to see here. The CartNarc will approach a gentleman who's in, looks like a utility van of some kind. The man is seated in the driver's seat, and they converse through the open window of the passenger door. And the confrontation escalates to a point where the man pulls a gun, the driver pulls a gun, cycles the slide in plain sight. He does have a guard dog in the van, by the way. It looks like it's about a 12-pound Chihuahua or something. But the man cycles the slide on his pistol, and the CartNarc runs away, calls the police, and has a brief interaction with the police at the end of this video. I'll play the video for all of you. There are no shots fired. No one's hurt. There's no gore, so we don't need any cautions here. I'll play the video through the encounter of the cycling and the slide, and then at the end, we'll come back to the interaction of the CartNarc with the police. And of course, the question is, could the cycling of this slide in an apparently threatening manner be justified, given the conduct of the CartNarc? Under Texas law, this all happened in Texas, so we will be looking at Texas law, specific statutes on non-deadly force in defense of property, deadly force in defense of property, personal property. That's what we're talking about here. Also, non-deadly force in self-defense, deadly force in self-defense, and try to come to a reasonable conclusion about whether or not this driver's conduct could be lawful under these circumstances, meaning, of course, that the prosecution could prove not the conduct, but disprove any justification this driver may seek to raise, self-defense presumably, and or defense of property. The prosecution would have to disprove those claimed defenses beyond any reasonable doubt. So let me go here and pull up the video. Here we are. And the first voice you hear is the CartNarc videoing his observation of the bad van driver who simply shoves his shopping cart up in the grass rather than returning it to the appropriate place. Here we go.
Classic again, the CartNarc. Oh, fully 4-quarter grass in it. And in his work truck, nonetheless. He's already in the door, so we'll approach from the front. Weepskeep wheel, weepskeep whoop whoop. That's not where the car goes, sir. Come on now. Said, you know the cars don't go there, sir. Agent Cordell here, CartNarcs. Get cart returns all over the place around here.
Are you going to get it for me?
No, sir, I'm a CartNarc. I narc out people that don't get their carts.
Oh, thank you. Yeah, let them know. Let them know I didn't put it back.
Well, I'm gonna let you know first. I'm giving you a chance to redeem yourself.
Oh, no, I'm good.
Why? How can you be good being a lazy bones?
Sorry, man. I hope you have a good day.
Well, I'm gonna give you our bumper hood of. Well, it's more of a service vehicle than a car.
This is my company. This is my truck. Don't touch it.
Well, this is just a magnet.
Don't do it. Don't put that shit.
It's non-marking, sir.
Don't put that shit on my phone.
Well, let me see. You see what it says?
Bam! There's the gun.
Sir, that's a gun.
Fucking car. Get the fuck out of here.
All right, he just brandished a weapon at me. That is the first for the CartNarcs. We're gonna get some data. We're gonna get some.
All right, I'm going to pause it right there. All he does is this lunatic CartNarc guy just keeps chattering to himself. Let's see if I can get to the part where right there. That's where the Glock is being displayed and cycled. Just as an aside, folks, I don't see a round coming out when he cycles the slide. I don't know why you'd be carrying a gun for personal protection without a round already in the chamber, but free country, people can do as they like, I suppose. So what's going on here? Why is this man displaying a gun? What's he protecting? Is he protecting himself? Is he protecting his van, his personal property? Well, Texas has a statute that allows for the use of deadly force in defense of even mere personal property, like a van. It's the only state that does that. Allows for the use of deadly force in defense of personal property in the complete absence of a threat to persons. So let's go ahead and take a look at that Texas statute. It is, by the way, you can always look this up yourself. Texas Penal Code 9.42. If you go to lawofselfdefense.com/942, this statute will pull up. And here it is right here. Now, I always caution people that, yes, Texas does allow for the use of deadly force in defense of mere personal property, even in the absence of a threat to persons, but it has a lot of conditions and a lot of subjective conditions. The first condition, and this is the statute, deadly force to protect property, and we're not talking highly defensible property. We're not talking your home, for example, or your business. We're talking just personal property, your stuff. In every other state in the country, you are simply not permitted to use deadly force in defense of personal property in the absence of a threat to persons. And if there's a threat to persons, it's not really a defense of property scenario anymore, is it? It's a defense of person scenario. So we have this unique Texas provision. Let's take a look at its many, many conditions and hoops that have to be jumped through. Well, the first hoop is that a person is justified in using deadly force to protect land or tangible, movable property, personal property. The first condition is you'd have to be justified in using non-deadly force to protect that property. So the first condition, number one, is if he would be justified in using force against another under Section 9.41. What is Section 9.41? You may ask. Well, I can tell you. It is use of non-deadly force in defense of property. Protection of one's own property. A person in lawful possession of tangible, movable property is justified in using force against another to the degree the actor reasonably believes the force is immediately necessary to prevent or terminate unlawful interference with the property. Well, would be putting a magnet on someone's vehicle be unlawful interference? Sure. So in this case, can you use non-deadly force to prevent that unlawful interference with the property? The CartNarc putting a magnet on your vehicle. It would appear so. Continuing, a person unlawfully dispossessed of property. Well, this is if your property's taken and you're recovering the property, which is not the circumstance here. So I'll just go through it quickly. A person unlawfully dispossessed of personal property is justified in using force against the other to the degree they reasonably believe the force is immediately necessary to recover the property. If the actor uses that force immediately or in fresh pursuit after the dispossession. So you're seeing someone running away with your property, you chase them down. It's not recovering property days later. You see them walking around wearing your jacket, for example, your stolen jacket. You don't get to use force to recover the property. You're expected to call the police to do that. But If you're in fresh pursuit or you're immediately using the force to prevent the dispossession of the property, that's okay for non-deadly force. So before you can use deadly force in defense of personal property, you have to meet those conditions first. So let's hop back to the deadly force in defense of personal property. You can use deadly force to protect personal property under Texas law if you would be privileged to use non-deadly force, and if you reasonably believe the deadly force is immediately necessary to prevent the other's imminent commission of, and then we have a bunch of enumerated offenses, most of which are, in fact, personal offenses, offenses against persons, arson, burglary, robbery, aggravated robbery. Those are all acts that create threat of physical harm to people. But we have a couple here that do not. Theft and criminal mischief. So is putting a embarrassing magnet on someone's vehicle criminal mischief with respect to that vehicle, their personal property? I would argue yes. So does that mean the CartNarc's threat to put the battery on this guy's vehicle would check off one of these enumerated offenses under Texas law? The answer is no. Why? Because this act we're seeing here does not occur during the nighttime, which is a condition of criminal mischief triggering the deadly force in defense of personal property provision. So you fail. Another thing I want to point out here is how often reasonableness appears in this privilege to use non-deadly and deadly force. Remember, before you can use deadly force in defense of personal property, you first have to be privileged to use non-deadly force under statute Penal Code 9.41. So as we read through this, we see reasonably. We see reasonably. We see reasonably everywhere, just for non-deadly force. And then when we get to deadly force in defense of property, what do we see? We see reasonably. We see reasonably. It's everywhere. And that reasonableness, folks, is not determined by the person defending the property. I mean, their sense of reasonableness guides their conduct, but that's not what determines the legal outcome in their case. What determines the legal outcome is not the defender's sense of reasonableness. It's the sense of reasonableness of other people who are not in the act of defending their personal property. It's the police, it's the prosecutor, it's the judge, and ultimately it's the jury. Now imagine you've used deadly force in defense of personal property. See if I can do this. There we go. Our social media people will be much happier with me like this. Okay. Imagine if this person used deadly force in defense of personal property and they've shot and killed someone in defense of personal property, and a jury decides, well, we just don't think that was reasonable. Guess what, folks? Then you don't have the protection of this statute. Let me go back to, there we go. There's the deadly force one. And if you don't have the justification of the statute because the jury disagrees with you about what was reasonable, you don't have a justification for your shooting of another human being. And that just makes it, what? Murder. Life in prison without possibility of early release. That's the risk you're taking because you don't know who your jury is going to be. You don't know how they view the world and use of force and guns. Heaven forbid the interaction occurred between people of different races. You don't know how that's going to be spun up for a jury. What if the person you shoot turns out to be a 6-foot-tall 15-year-old, described by the police, by the prosecutor, as a child? You killed a child over personal property. Stuff that's just money could replace it. And you took a human life. How's the jury going to perceive that? And if they decide against you, it means the rest of your life in a cage without possibility of early release. That's the risk you're always incurring when you attempt to take advantage of this statute. I don't tell people what to do. I'm not telling you to defend your personal property with deadly force or not defend it with deadly force. But I do want you to make an informed decision. Those are the stakes. Are you willing to go to prison for the rest of your life over a piece of personal property? And your answer may be yes, and that's fine. I'm not telling you not to take that position. I just want you to do it in an informed way. So it would appear, under the facts of this case, because the criminal mischief that arguably was taking place, the threat to put the magnet on the driver's vehicle, did not occur in the nighttime. So 9.42 would not apply to this particular circumstance if we're talking about the use of deadly force to protect property. Fair enough? Let's take a look at a different possible justification, and that is the use of deadly force in defense of persons. So, of course, as you might imagine, Texas has statutes for that too. Here's their self-defense statute. And the way many states structure their self-defense statutes is they'll have a first paragraph of self-defense that talks about non-deadly force in self-defense. And then they'll have a second paragraph in the same statute that talks about deadly force self-defense. That's how Florida does it. For example, we just looked at Florida statutes in a recent law self-defense show. Texas does it slightly differently. They have statute 9.31, which talks about non-deadly force in self-defense. And then they have statute 9.32 that talks about deadly force in self-defense. So instead of two paragraphs in the same statute, they have two separate statutes, which is totally fine. It's just an alternative way of addressing the question of proportionality. When can you use deadly force in the context of defense of persons? Typically, you need to be facing a deadly force threat. So deadly force to deadly force, that's the element of proportionality. You ought not be using deadly defensive force against a non-deadly force threat. So in this scenario here, we have the CartNarc threatening to put a magnet on this driver's vehicle and being confrontational, right? Approaching proximity to the vehicle, even though the driver is telling him not to. Is there a possibility here that the driver was perceiving some kind of personal threat from this CartNarc who's presenting as a lunatic? I mean, this is not normal behavior. So is it possible the driver would say, or his lawyer would say, well, yes, my client displayed a firearm, arguably in an aggressive manner, but he was doing it in self-defense. Deadly force self-defense. Perhaps, but how credible is it that the driver was perceiving a threat of death or serious bodily injury, or was perceiving a threat to unlawfully breach the vehicle, for example, enter the vehicle? Maybe, I mean, you could make that argument. Maybe it would be genuine. We don't know what the driver was hearing, right? We know what we hear, that it's just a magnet. But it's possible the driver might have been perceiving some greater degree of threat, but it would be difficult to substantiate that strongly on the evidence we have available here. So I saw a lot of Twitter commentary on all this, and it's the general conclusion seemed to be that, well, this can have been lawful. The driver cycling the slide of his gun in that threatening manner because he wasn't facing a deadly force threat, and so defense of self wouldn't apply, and criminal mischief was not occurring during the nighttime, so deadly force in defense of property, personal property, would not apply, and therefore this must have been unlawful conduct by the driver. Here's the thing, folks. The driver here did not actually shoot the CartNarc. He arguably threatened to shoot the CartNarc, at least implicitly through his conduct of cycling the slide, but threat of force and use of force are not always the same things. In fact, they're rarely the same things. There are states that treat the mere threat of deadly force in much the same way as they treat the actual use of deadly force. So Massachusetts, for example, if you threaten someone with deadly force, you need to have the same justification available to you. The same conditions have to be met for a threat of deadly force as would have to be met for the use of deadly force. So the same circumstances would have to have justified you in shooting that person before you'd be justified in threatening to shoot that person under Massachusetts law. And it's just a public policy decision by the Commonwealth of Massachusetts. Basically, they're saying we don't want people to be even threatening deadly force unless they'd be justified in shooting, because it's so likely that a threat of deadly force will lead to a use of deadly force. Most states do not take that approach. Most states will treat threat of force and use of force differently. Now, of course, the criminal charges that can result are always different, right? If you shoot someone, and they die, it would be murder or manslaughter, right? Among the most serious felonies possible. If you shoot them, you actually use deadly force, and they don't die, it could be some kind of malicious wounding. It could be aggravated battery with a firearm, so you get a sentencing enhancement for that. If you don't fire a shot and you only threaten to use deadly force, well, that's the criminal offenses you're facing then are substantially different. Presumably, it would be at worst aggravated assault, putting someone in imminent fear of death or serious bodily injury. It could be a brandishing charge, right? Displaying a weapon in a way to put someone in fear. And for all of these, you would, of course, be raising the legal defense of self-defense or defense of others or defense of property. But how does Texas treat this? In a lot of states, it's very ambiguous. It's very clear what the actual use of deadly force requires in order to be justified. But it becomes a lot more ambiguous when the mere threat of deadly force is done. You're facing the same kind of criminal liability I just described, right? The brandishing, aggravated assault, even if you never harm the person, aggravated battery if you shoot them and they live, manslaughter, murder if you shoot them and they don't live. So we have that whole spectrum of criminal liability. But the legal defenses become more ambiguous if you merely threaten. There's a lot of prosecutors out there who, when they're dealing with these kinds of cases, display of a gun cases, and folks, most of the cases I consult on are these cases. Display of a gun, no shot ever fired. And the person who displayed the gun because they got scared ends up charged with aggravated assault with a deadly weapon, and they're looking at 10 to 20 years in prison. Felony time, typically 10 years for the aggravated assault and another 10 years for the firearm sentencing enhancement. And these are typically people who've never been in trouble with the law a day in their lives. And now they're looking at 20 years in prison, and they can't believe they're getting prosecuted for self-defense. Most common thing I hear on these cases from the clients. They just can't believe it because in their minds, they know they're the good actor, right? The lawful person. Unfortunately, they don't know. They didn't know in the moment what kind of unbelievable legal liability they were creating for themselves by displaying this gun. If other people who are evaluating their threat of force in hindsight decide it doesn't look like justified self-defense or defense of property to them. A lot of prosecutors' offices will have some kind of informal policies about this kind of thing. So if you display if you make another party aware that you have a gun and you're prepared to use it, they'll generally give that a pass if there's any credible narrative that you are facing a reasonably perceived threat, even if the threat was not necessarily deadly in nature, which is what proportionality would require for the actual use of that gun. If you take the gun out of the holster, if you bring the gun to a low ready, if you put the muzzle on the person, well, each of those escalating steps, the prosecutor will examine more rigorously and be less likely to give it a pass, depending on the degree of threat. The trouble is, these kind of informal policies in the prosecutor's office they're not laws, they're just policies. So the prosecutor may routinely say, all right, you put your hand on your gun in a way that made that other person aware you had a gun and were ready to use it if necessary. We're not going to charge that as aggravated assault with a deadly weapon. But if you draw the gun and you put the muzzle on them, yeah, we're likely to charge that as aggravated assault with a deadly weapon, unless we believe you have a genuinely compelling narrative of self-defense. And maybe even then, and we'll let the jury decide. So in a lot of states, it's very ambiguous because there's not clear black letter law on these distinctions between use of force, mere threat of deadly force, and the differing degrees of intensity of threat of deadly force. Texas, helpfully, has a specific statute on this question. Let me pull this up right here. Penal Code 9.04, threats as justifiable force. The threat of force, not the use, the mere threat of force is justified when the use of force is justified. Okay, fair enough. For purposes of this section, a threat to cause death or serious bodily injury, so a deadly force threat, by the production of a weapon, which is what we have here, as long as the actor's purpose is limited to creating an apprehension that he will use deadly force if necessary, that he will use that deadly force if necessary, does not constitute the use of deadly force. So when we look at this driver's conduct, is he likely to claim, I produced the weapon for the limited person of creating an apprehension that I will use deadly force if necessary? Therefore, under Penal Code 9.04, my display of the weapon was not a use of deadly force. The display of the weapon was merely non-deadly force. What are the conditions for the use of non-deadly force in defense of persons or in defense of property? They're very low. Let's take a look. For example, at 9.41, protection of one's own property with non-deadly force. If you're in lawful possession of tangible property, you're justified in using force, here meaning non-deadly force, when you reasonably believe the force is necessary to prevent or terminate the other's unlawful interference with the property. Was it reasonable of this driveway to believe it was necessary to make a non-deadly force display to prevent the criminal mischief, the putting of the magnet on his vehicle? I would say yes. I mean, he told the CartNarc not to do it, and the CartNarc was insisting he was going to do it. So verbal deterrence was not working to prevent this criminal mischief. Are you then privileged to use non-deadly force, which the display of the gun is under Penal Code 9.04, as the next step to prevent the criminal mischief? I would argue yes. Exactly so. Now, keep in mind, if he'd actually used the force, he wouldn't be covered by Penal Code 9.04, right? Then he'd have to justify not the mere display of the weapon, but the actual use of deadly force, and the criteria would be much more rigorous. It would be either Statute 9.42, deadly force to protect property, or it would have to be Penal Code 9.32, deadly force in defense of persons. But that's not what happened here. What happened here is the production of a weapon under Penal Code 9.04, which says that that's merely non-deadly force. At worst, it certainly does not constitute the use of deadly force, so long as the production of the weapon is limited to creating an apprehension that he will use it if necessary. So, we have a little more of this video because the CartNarc actually calls the popo. The police come and show up. He's very upset. Of course, he's got these the driver's information. And here's what happens when the police get on the scene and investigate.
Okay, so I even spoke to my supervisor about it, and his mind is exactly where mine is. It doesn't quite meet the elements of the Class C misdemeanor. Brandishing is actually different in Texas. It's got to be a little bit different. But this would come under, if it met the full elements of it, would be a Class C misdemeanor, which would be disorderly conduct by displaying a firearm.
Okay.
However, it kind of has in there that it's on somebody else's property, it's in his own truck, he doesn't know what's going on. I'm not saying that's the case, but I'm saying that's what he's going to say.
I can play the audio that says a different story completely.
The attorney is basically going to say the elements aren't met on it. We're not going to be able to charge the guy.
So the police are proving unhelpful. They didn't give a very good explanation of why they were not going to be pursuing charges against the driver of the truck here. But as we see, they're arriving at the correct conclusion under Texas law. All right, folks. I'm going to take a look now at the Law of Self-Defense member chat. If you're watching this on YouTube and would like to make a comment or ask a question, I'll be happy to address that. It just needs to be in the form of a $10 super chat. Or alternatively, what I would really recommend is that you not pay YouTube $10 super chats, but that you instead become a member of Law of Self-Defense, which you can do for the same $10 a month. In fact, you can try it out for 2 weeks for just 99 cents. Standard membership at Law of Self-Defense, 2-week trial, unlimited access to all our members' content, the ability to ask as many questions as you want during these live streams and get them answered for free. Just 99 cents for 2 weeks. After the 2 weeks, it's only about 30 cents a day. It's less than $10 for a month of membership at Law of Self-Defense. You can take advantage of that at lawofselfdefense.com/trial, or you can pay YouTube $10 and do it as a super chat. That's up to you. But I recommend the membership option. I mean, it doesn't make any sense to me to do anything else. Let's see. I need another window here so I can check out the super chats when I need to. Let's see. But first, we do the Law of Self-Defense member chat. Here we go. Chuck, Law Self-Defense member Chuck says he was on Dr. Phil. Is that the CartNarc was on Dr. Phil? That would be pretty funny. George says, magnet versus gun. Not sure that fits the element of proportionality. Well, see, the thing I love about the Law of Self-Defense community is they may not know the right answer because they may not have done the kind of course, legal research that I do routinely as part of my job, but they know the right questions. And that is the right question, the question of proportionality here. Most of the general public doesn't even know the right question. So, of course, they have no hope of ever getting to an answer. Jeffrey says, Law of Self-Defense member Jeffrey says, people who don't return their carts in most cases did not earn respect, but I would never drop myself to their level by calling them out. Just whatever you may think about people who don't return their carts. Remember, folks, every time you engage in this kind of confrontational behavior, what are you doing? You're incurring 2 risks you were not incurring a moment before. You're incurring a risk of death if that confrontation escalates to the physical level. There's no guarantee that the good guy wins the fight. And you're running a risk of spending the rest of your life in prison if it does escalate out of control and you find yourself compelled to use deadly force and the people judging your conduct afterwards decide they don't think it was justified. Over what? Over a shopping cart return? Law of Self-Defense member Jim says, when I lived in New Jersey, it was rare to see someone put a cart back. In Tennessee, I rarely see a cart that hasn't been put back. Yeah, there are cultural dynamics here. I've never lived in New Jersey, but I have family that lives there. A lot of the supermarkets there I've seen have a mechanism on the shopping cart where they're chained together. You have to put a coin in, a quarter maybe, and to unchain the shopping cart. And then when you bring it back and you chain it back up, you get your quarter back. That's one way to do it, I suppose. Let's see. Law of Self-Defense member Zakuza says, I used to be a mobile storage unit guiding specialist in high school. I guess that's a cart attendant. The layman would say cart attendant. Yes, it's not my fault. People are uncultured. It's really not that hard to put the cart back. Yeah, I mean, it's a nice thing to do, right? It's nice when the parking lot has plenty of places to put the cart back. That's very helpful. Law of Self-Defense member Jeffrey says, I think it's funny the CartNarc was acting surprised that Texan had a gun. My only surprise is it was a gun that didn't already have a round chamber. Jeffrey says, not that I would condone pulling a gun in that situation. Yeah, I don't think it's a good idea, folks. I think under Texas law, it was probably legally justified. But it creates all kinds of potential legal liabilities and problems that don't seem warranted by the circumstances. For me personally, I mean, I've carried a gun every day of my adult life. and I've never come close to using it. And if I ever have to use it, it's going to be because innocent human life was at risk of being eminently taken by some unlawful act. It's not going to be over a shopping cart dispute for sure. Law self-defense member Scott says, not a particularly good idea to display the gun, not worth the chance of an aggravated assault charge for a magnet sticker, especially in those Texas cities with more liberal DAs like Dallas. Yeah, it's important to keep in mind, folks, that even in states we think of as solid red, the cities are not red. The cities are blue as blue can be. And a lot of them are very anti-gun, regardless of whether the state generally has a gun-friendly environment. And these prosecutors have absolute discretion on whether they want to charge you and feed you into the criminal justice system and cost you a fortune and put you at real risk of being convicted, getting felony time, losing your gun rights forever. There's never a zero risk of conviction if we have to put you in front of a jury, folks. It's probably at the low end, 10%, at the high end, 50%. Well, at the high end, probably the average end is about 50% probability you get convicted. And I don't care how innocent you are. Let's see. Law self-defense member Scott says, CartNarc did point an open-ended stick-like device at the driver. Do we assume it's a flashlight? It looked like one of those flashlights with the orange cones on it to me. Could the driver have misperceived that item as some kind of weapon? Maybe. If he did, then he'd be really making a defensive self argument as opposed to a defensive property argument. If he had a reasonable perception, even if mistaken, that he was being threatened with some kind of weapon, well, then it's a deadly force self-defense analysis at that point. Let's see. Law self-defense member Scott says, kind of glad my truck has an aluminum body. That's helpful because guess what doesn't stick to aluminum? Magnets. Law self-defense member Lou says, when I dress and arm to go out in public, I have to remind myself to behave appropriately and avoid stupid criminals before I leave the house. Prudent. Law self-defense member Taylor says, unrelated, but had a road rage incident where I was acting a fool. Guy decided he didn't like me, flipping him off, and proceeded to chase me down. Ended up brandishing after he wouldn't leave me alone. Glad nothing came of it, but I reflect on that sometimes. Yeah, that's exactly what I'm talking about, folks. When I talk about once you get engaged in this confrontation, you have no idea how it's going to spin up. You don't know who that other person is. You don't know what they're capable of. You don't know how irrational they are. Maybe their wife just filed for divorce that morning and they're really pissed. And they're just looking for someone to take it out on. All right, let's see. I think that's all the member chat. I'll take a look now at the super chat. I'll come back to the members in just a moment. I'd like to think that we don't have any super chats. I'd like to think that all those people are instead deciding to spend 99 cents with me for a trial membership at Law Self-Defense and not just give YouTube $10, but who knows? And hopefully everyone's doing that right now because, in fact, there are no super chats from today. One more look at the member chat. And then I think we can wrap up today's show. All right, that looks all good, folks. So, last reminder, our Law of Self-Defense. Where'd you go, buddy? Where's my little thing? Here it is. Law of Self-Defense. Where is it? There it is. Advanced class this Saturday, October 7th. This Saturday. Saturday. Last one for 2023. We won't be doing this course again until spring of 2024, folks. 6 months away. This is our full day live streamed course of instruction on understanding self-defense, defense of others, defense of your family, defense of property, interacting with the police, developing your own legally sound self-defense strategy, how the criminal justice system actually handles claims of self-defense, difference between the very common bad guy claims of self-defense versus the much less common good guy claims of self-defense, and much, much more. And we only have a few seats available. We have a cap on our Zoom account for how many attendees can be in one of these streamed courses, and we're bumping up against that cap. So now would be the opportunity, folks. Grab your seat today at lawofselfdefense.com/advanced. And with that out of the way, I'll just remind all of you that if you carry a gun, so you're hard to kill, if you carry a knife, so you're hard to kill, if you carry pepper spray, so you're hard to kill, if you practice jujitsu, so you're hard to kill, I do all those things so that I can be hard to kill. So my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.